Welcome to the Western PA Work Injury Podcast.
Welcome to the Western PA Work Injury Podcast with attorney Mike Russell. With 33 years of experience representing injured workers across Western Pennsylvania, Mike focuses on helping clients navigate workers' compensation claims and protect their income and benefits after a workplace injury. I'm Lisa Mosbey, and today we're talking about what happens if your workers' compensation claim is denied in Pennsylvania and what steps you can take next. Welcome back, Mike. Thanks for joining me.
Good morning, Lisa. Hopefully we can help shed some light for some injured workers in the state.
That's the goal. So, Mike, what does it mean when a workers' compensation claim is denied?
Well, the simple answer, Lisa, is first of all, I'd say the first reminder I'd give everybody is you got 21 days to get a decision from a workers' compensation carrier on what their intent and plan is, assuming you're off work. So we'll just take the simple case. You have an injury, you're off work. They've got 21 days to decide whether or not to pay you. There's some different ways that they can go about either paying or not paying you or partially paying you, but we'll take for purposes of today a relatively simple example where they issue a blanket denial. A blanket denial means they're not paying for your wage, they're not paying for your medical expenses. So at that point, it's incumbent upon the injured worker to make some decisions on what they're doing moving forward. Obviously, if they're off work and they need medical treatment, they need to find a avenue to get their treatment and get paid some wages so their bills are paid. The reality is, as I've said in our prior podcast, it's critical that you have an attorney even early on. Attorneys work on a contingency fee basis. So typically there's no fee, and it's really critical that you have an attorney at the outset of your case that can kind of prepare you for the battle that's coming. But the answer to that question is when a claim is denied, then it is time to get out, as I tell my clients, the baseball bat and start the fighting, because at that point, if you do nothing, then your claim will remain denied. And at that point, it's time for you to file a petition. And there's steps that we need to get to before we file that petition. And you need a lawyer in there directing you and guiding you to get your case ready for that battle that's coming.
And Mike, what are some of the common or most common reasons claims get denied?
Simple answer to that question is there really isn't a reason. I have clients call me, having done this for as many years as I've done it. I've had clients call me just insanely upset that their employer issued a denial and they're not paying their bills. They don't understand why. They fell at work, they hurt their back, didn't have any prior problems. The reality is, and maybe we can or cannot see this in the purposes of this, but there's a little form that is the basis for a denial of a comp claim. So the front of that form that I just showed basically has the parties. There's nothing in there. And the meat of the form, and I say that with a bit of a grin, the meat of the form is the back. And the back side of that form has 5 boxes. And those 5 boxes are the methods by which a carrier denies a claim. I tell clients that the employer and carrier, and I use those terms interchangeably because in Pennsylvania, they're one and the same. The employer has an absolute right to deny the claim, and then it becomes your responsibility as the injured worker to prove your case and fight to get the benefits that you deserve. So there are 5 boxes on the back of that form, and they're just check marks. The first says that you didn't sustain an injury. So you fall at work and your claim is denied. You didn't have any prior problems. They check the box saying that you didn't sustain an injury. Case is denied. There's no more rationale. There's no more evidence that they offer in that. It's just you didn't sustain an injury. Box 2, that's the box we see more frequently, just a box 1 denial. They didn't sustain an injury. Number 2 is you didn't get hurt during the course of your employment. That might be that you were on a break. I have a case right now where a client was on a break, taking a walk with some of her coworkers, and had an injury. So that kind of denial comes up. But again, it's a checkbox. They check the box, case over, you're on your own. The other box 3 denial is that you are not an employee. So if there's any indication in the carrier's mind that you're not an employee at the time of the injury, that one we don't see all that often, to be blunt. I've seen that on a couple of cases over the years where we have somebody that works for one employer, but there's a family business and they're over actually working at the brother's business or the sister's business. So we run into that one infrequently, but every once in a while. Number 4 is you didn't give notice within 120 days. As we talked about in our prior podcast, it's critical that you give notice of your injury, let the employer know that you had an injury, how it happened, and what kind of injuries you have within 120 days. And as we talked about before, you ought to do it immediately and not wait any time at all, because that can create other problems. The fifth denial is the only one that asks for any explanation, and the fifth denial is other good cause, and it asks you to explain. So I've seen explanations like we're pending investigation. We see that frequently. So the carrier gets a notice that an injury occurred. They don't know much about the case at that point in time. And then they issue a denial saying, we don't have enough information yet, so we're denying it. The key is here, to the great chagrin of most of my clients, is there really isn't an explanation. I've had clients so many times saying, well, why'd they deny it? Because they have the right to. They have some risk when they deny it without cause, but there's not really that much. And so the denial basically means it's now incumbent, as I said, on you to take some action. And there are some critical steps that we're going to take to get you to the point that we can then go after fighting for the benefits that you deserve.
Wow, it's really detailed on these things, and if somebody doesn't understand it, I think it can also be really confusing. Can you walk us through a real example of a denied claim and how it was handled?
That question was kind of apropos, because the example that I have in my head is of a young lady. We will call her Lisa, so her name is not revealed. But Lisa's case just went to a decision relatively recently. And as you say, it's very confusing. And the one thing I would say, and as I've said a number of times during the course of my podcast, is that we have to have an attorney in place. You really need an attorney, because you can't do this on your own. Not only can you not litigate a case on your own, you're allowed, but you really can't. But you can't prepare properly to the point that your case is ready to go to court, that your case is prepared, that the battle lines have been drawn, and you've done and taken the right steps to put your case in a position. So Lisa had an injury back in January of 2024. She was not represented. She did not seek counsel. About 2 months later, in March, the workers' compensation carrier finally issued a denial. Again, 21 days. If she had been talking to me at 22 days, we would have filed a petition and begun the process of going after them, because they hadn't done what they were supposed to do to make a decision on whether or not she was to get paid. Unfortunately, she waited till March. Denial was issued, and unfortunately, she didn't do anything again. Maybe she didn't understand her rights, but nonetheless, it took her another 5 months. So we're now 7 months after her January injury. In August, when she's filing a petition, we call it pro se, but that means on your own without the benefit of counsel. So she files a petition in August. That petition gets assigned to a judge. That judge schedules a hearing. She comes into the hearing, and what every judge in the Commonwealth is going to do is look at her and say, you really need an attorney. You have the right to do this on your own, but you genuinely can't. It takes the skill and practice an understanding of an attorney who's been practicing in this area to be able to litigate your case. You can't do it on your own. So she's now in September, ultimately realizes she needs a lawyer, comes to me right after the hearing. We get involved immediately. Hearing gets scheduled in late October. So now, mind you, we're now 10 months basically after the injury, and the case is just getting started. So she goes to that hearing. She testifies in October. They send her to an exam. First hearing's just a real quick hearing. Usually they might testify at that hearing, but that's just the start of I tell clients, rolling the ball down the hill. That's the start. So she gets examined by one of their doctors. I get medical evidence from my doctor. And ultimately that case finally goes to a decision. And I almost said her name, Lisa won the case at that point in time, and was approved the benefits that she realistically needed to fight for sooner. So the key is you need to have an attorney. Real life examples. I have war stories of hundreds of those kind of cases where people didn't do what they needed to do, and called me lengthy time, sometimes almost 3 years after an injury, and say, I got injured 3 years ago. I want to fight for it. And they've missed work throughout that period of time. So it's really critical to get a lawyer in place so that you can do things that need to be done to prepare your case for battle.
I like that you use a story to bring that point home because we don't always think about that. We don't realize this is a lengthy process. You went through the checklist on the back of that form. After a denial, what options does an injured worker realistically have?
The options are quite limited, unfortunately. As I've said, it's
Mm,
incumbent upon that injured worker, and it's really no different than a personal injury claim. If you get in a car wreck, it's somebody else's fault. You don't get paid automatically. You end up having to wait. You end up getting your treatment. You file a court case. Comp runs a little different, but the general concept is the same. The general concept is if the carrier denies your claim, your option is to prepare and take the case to a battle. So the practicalities are that you have to file what's called a claim petition. So when a claim is denied, once we have, and I emphasize that, once we have taken the proper steps to create a case that's in position to be fought, then we're going to file a claim petition. And what that means is you come to me a month after your accident, um, they've denied your case. We're not filing a case for you at that point. Um, in order to prevail, there has to be a case. There has to be evidence that's going to support that litigation in front of a judge. So if I file that case 1 month in and I don't have any real treatment that supports that there's an injury, that there's disability, I'm going to show up in front of a judge who's going to look at me and say, well, Mr. Russell, what's your case? I don't see any medical here. What's going on? And that case can summarily be dismissed by some of the judges. Some of the judges are a little more patient. They'll let us work for a while to get some things in place. But that's not the best way to do it. Again, that's why it's critical that you have a lawyer. So
yeah.
you need to get some insurance in place. One of the first things that we tell people is when you have an injury, often, not always, but 95% of the time, your employer-based health insurance ends. And I can't fight a case to get you workers' compensation benefits unless you're seeing a doctor who's going to say you had an injury, right? And so we're directing our clients in the process of getting insurance in place through welfare, through the penny, which is the Affordable Care Act, or some method by which they can get some insurance in place now that their claim has denied. Common misconception: if you had a work injury, and I argue with clients frequently about this because they don't think their health insurance should pay. But once a claim is denied, your health insurance is obligated to pay those bills. And again, if you're not treating, I can't go to a judge and say, I think you had a work injury. We have to have a doctor who's going to say that. And so we get insurance in place. There's some things that we direct people to so that they can get the proper kind of treatment. But ultimately, all those things fall into place over the course of a few months, hopefully as quickly as we can. And then ultimately, we file a claim petition, and we're heading for litigation. The case goes in front of a judge, and patience is the word of the day. Patience is required. These things do not happen overnight. First hearing is typically 6 weeks or so after the accident, and that's just the first of probably 3, 4, maybe 5 separate hearings. So it is a long battle, but it is a battle that you have to fight if a denial is issued, and you need help doing it.
And how important is timing after a denial, and what deadlines or time limits should people be aware of? You mentioned 120 days and a couple of other things. So let's kind of break down that process and give folks an idea of what it looks like.
Well, the 120 days is even before we're in litigation. 120 days to file notice. If someone wants to go back and listen to one of our prior episodes, Lisa, they'll hear me talk about the fact that notice is critical. If you don't give your notice in 120 days, you are out of luck. Case over, done deal. You get zero. Critically, however, what I direct and tell people to do is not even wait. People don't want to lose their jobs, so they're afraid to give notice. Give your notice. Get that in there so that there's no issues. Um, Once we're done with that, then the time frame from that point forward is pretty lengthy in the Commonwealth. Once you've given notice, you have 3 years to file a claim petition in the workers' compensation system. So you have plenty of time to do it. Reality is most of those clients aren't working. They're not getting paid. Their medical bills may or may not get paid. And so they're running out of money rapidly, sometimes almost immediately. So it's important to get things moving quickly, and kind of get that process moving forward so you're not in that position where you're in trouble.
You mentioned, they're not getting paid and the medical bills are adding up. What happens to someone who's fighting a denial and those things are they're experiencing those medical treatment costs and loss of income? Do they have any options? Like once they file a claim, is there any assistance? Tell us a little bit about that.
Unfortunately, the reality, Elisa, is there are very few options. I've been
Oh,
doing this now for 33 years.
mhm.
And at the outset of my practice, I began to realize that people that get hurt at work end up oftentimes losing everything. If it's an obvious injury that picks up and they start paying the benefits, that happens. But I've litigated, never counted, but I'd say probably tens of thousands of cases where people weren't being paid. And one of the first things I realized is this is a long, drawn out process. Litigation often takes over a year. And that's after that time period that we just talked about, where you get the case up and ready to be filed. So we're now a year and a half out. Most people can't live for a year and a half without
No.
any income. So personally, one of the first things I did once I started seeing this and seeing the impact of the lack of any income on people, I went out and bought myself a disability policy that I've had in place since probably 1998, so that if I get hurt at work, I am covered even as an attorney. So, just I guess a side note is if you listen to this and you're working and you're not injured and you have an option to pay for a short-term disability policy through one of those benefit companies like Aflac or Guardian, get it in place, because the fact remains is I file a claim petition. Let's say we get it filed in 3 months. You're probably 15 to 16 months with no income until you win your case. And I have seen people lose everything. I've had um, countless, and I mean countless clients have their vehicles repossessed. I've had clients sell watch collections that they have passed down from grandfather to great grandfather down the line, and they're in there and they're ready to give them to their kid, and then they have an injury and they can't pay their mortgage. And so they're selling things that are of great personal, family value. So it is a long process. Medical's often easier if somebody has followed my guidance and has an attorney in place, because that attorney's got them in a position that they have some other health insurance. So somebody's paying their bills. There's co-payments that we don't have in Pennsylvania work comp, but at least their bills are getting paid for their health insurance, but nothing else. As I suggested in one of my earlier podcasts, nothing else gets paid. Your rent doesn't get paid. Your mortgage doesn't get paid. Your health insurance premiums don't get paid. Your car payments don't get paid. And it can be disastrous to a person or a family when there's no money coming in. So we prepare for it and we get that case going as quick as we can. But the good thing, hopefully, is people will listen to this and prepare ahead of time so they're protected in the event that they do have an unfortunate injury.
And that's some great advice about the disability insurance. Not something I was even thinking about, but um, as we come to an end here, I'd love for you to take just a minute to let somebody who's listening know what kind of evidence or documentation they need to keep track of if they've experienced an injury.
I probably sound like a broken record, Lisa, but I go back to the same thing. You need a lawyer in place, particularly a lawyer that has practiced in the field
Okay.
of workers' compensation, that understands the system that you don't understand, and understands medicine in a way that you perhaps don't understand. Um, any attorney that's been practicing in this knows where to direct you. I try really hard not to refer clients to particular doctors, but I have to on some occasions do that because I know every doctor. I've seen most of the orthopedics. I've seen most of the pain management physicians. So there is an unfortunate reality that some doctors are willing to treat patients, but they're not willing to fight for them. There are doctors who are willing to treat patients, but are more apt to get them back to work. Frankly, I'm a fan of getting somebody back to work. One of the things I encourage people to do after a work injury, which is sometimes difficult for them. They have an injury, they feel like their employer has betrayed them because the work comp carrier has denied the case. So we get this friction between a client, sometimes who has worked there many, many years. And so uh, they don't really want to talk to their employer. They blame their employer for the fact that they have no income and their car just got repossessed. But I'm a huge fan of making sure that that relationship is intact as much as we can possibly make it. Sometimes it's not possible. Sometimes the employer genuinely is upset, and so there is no desire for a relationship on that end. But I want my clients to maintain their relationship with their employer, with their supervisors. I want them to be in touch with them. I want them to provide slips. My hope, I need to make a living, but my hope for every single client that I represent is that they're going to get better and they're going to have a job to go back to, and maybe they don't even need me to fight for them. That's the best case. I mean, people benefit from working, but sometimes that's just not the reality of the injury that they sustained. And so we need to make sure that they're treating with the proper kind of doctor, that they're seeing the right doctor. Many, many clients have come to me over the years and they've gone to their primary care physician. Um, Primary care physicians are great, but if you have a back problem, they're not the doctor that's going to fight your case for you or help you. I tell clients, your family physician treats colds, flus, and foot fungus. He's not going to win your case because he's going to be fighting against a doctor on the other side who is an orthopedic surgeon or an orthopedic physician or a pain management doctor. So the attorney can direct you in the right course of action so that you're building your case and preparing to fight. That medical evidence is critical. I can tell you, Lisa, I have probably 300 open cases right now, and every single one of them, I have a doctor on my side who's in my client's corner, but I have a doctor on the other side. And the diametric opposition never ceases to amaze my clients, that this doctor can say they had an injury and they can't work, and this doctor can say they don't have an injury and they can work. But that's where we're at. And so we need to have a doctor on our side that is able to testify, willing to fight, and not just provides proper treatment, but is prepared to fight for somebody so they don't end up not being able to pay their bills.
Mike, this is a lot of insight. It's been an excellent episode. Thank you so much for your time today.
My pleasure.
Folks, that's it for today's episode of the Western PA Work Injury Podcast. If your workers' compensation claim has been denied and you're trying to understand your options, you can learn more or get in touch with attorney Mike Russell at attorneymichaelrussell.com. Thanks for listening, and don't forget to subscribe, share, and leave a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.